The Department of Treasury has recently issued new guidelines on tax refund offsets, one of the enforced collection efforts the department uses to collect on defaulted SBA loans. Tax refund offset is withholding or reducing a tax refund payment by an amount necessary to satisfy a debt owed by the payees of a tax refund payment. Creditor agencies are generally required to submit their delinquent federal non-tax debts to Treasury for tax refund offset purposes, and Treasury, as a dispersing office, is generally required to offset tax refund payments to collect submitted debts. Prior to using tax refund offset, agencies must first attempt to collect the debt. It is not delineated what constitutes a sufficient attempt to collect, but the SBA will meet the requirement by taking minimal steps toward collection, such as issuing a demand letter and providing due process. Federal regulations state that the SBA must attempt to collect prior to using tax refund offset. Does not require that the agency first report the debt to a credit bureau or attempt to collect using administrative or salary offset. Prior to collecting a claim through tax refund offset, agencies must first notify the debtor that the agency proposes to use tax refund offset to collect the debt. This notice must be sent at least 60 days prior to conducting a tax refund offset. While agencies are strongly encouraged to provide written notice, the agency can determine for itself the method of notice to use. Notice can be provided through first-class mail, certified mail, or email, so long as it is reasonably calculated to notify the debtor, regardless of whether the debtor actually receives notice. In addition to providing notice, agencies must provide the debtor with an opportunity to dispute the use of tax refund offset in a manner that meets minimum constitutional requirements for due process. Prior to using tax refund offset, agencies must first provide the debtor with at least 60 days to present evidence that all or part of such debt is not past due or not legally enforceable. Agencies must review any evidence presented and inform the debtor of the results of their review. No court has jurisdiction to review Treasury's actions to offset a federal tax refund payment. The Internal Revenue Code deprives courts from having jurisdiction to hear any action, whether legal or equitable, brought to restrain or review a tax refund offset. Courts do, however, have jurisdiction over the creditor agency's actions. The Internal Revenue Code does not preclude any legal, equitable, or administrative action against the federal agency or state to which the amount of such reduction was paid. If you are facing an SBA loan default, contact us today for a free initial consultation with an experienced SBA workout attorney at 888-756-9969 or find us at www.sba-attorneys.com. We will analyze your SBA loan problems and advise you on potential solutions such as an SBA offer in compromise for your SBA loan default.